He is Greg Willard, St. Louis University law professor, friend of the show, KTRS's legal analyst, and a man who is in a unique position to talk about all the things going on. He was a White House staff assistant when the Gerald Ford White House. Then he became his personal attorney, and now he is an attorney for the Gerald Ford Trust. Greg Willard, welcome to Big 550 KTRS.
Good morning, McGraw.
Let's talk about Neil Gorsuch, who was just announced as President Trump's Supreme Court pick. Do you know him, and what are your thoughts as you see this?
I do not know him personally. I think we can put down a couple of axioms this morning, McGraw. Number one, the sun will rise in the eastern sky tomorrow. And number two, Neil Gorsuch, by any measure, is eminently qualified to be an Associate Justice of the Supreme Court, period, full stop.
Right, which puts the Democrats in a box because they have nothing to hang their opposition on. This man seems like a perfect pick, so they have no way to go at him, so they can't criticize the pick. They can't do anything except sign off on it.
Well, if we were in your and my eighth grade civics class, perhaps that would be true. The reality, McGraw, is they will go after him with every scintilla of opposition they can. The fact that he is qualified, I don't think will enter into the discussion. Senator Markey has already said he's going to filibuster. So I think, as the saying goes, fasten your seatbelt. This is going to be a horrifically bumpy ride.
Democrats still very angry over the Merrick Garland situation where he didn't even get a hearing.
In the eyes of the Senate Democrats, McGraw, this is a stolen seat. That ninth seat on the Supreme Court, in the eyes of Senator Schumer and others, that should have been President Obama's pick. Then Majority Leader and currently Majority Leader McConnell last year refused to even hold hearings on the Merrick Garland nomination, and the Democrats, A, are bitter, and B, they will not forget that.
Let's talk about this nuclear option they keep talking about, because people don't understand it. I don't think I understand it. I don't think the senators don't really understand it, because it's very confusing. They need 60 votes to get this through, if you will, or to get it out of committee to a full floor vote. That means you need 8 Democrats to go along. There is an option where they could do away with that law and just get 50 votes, and there are enough Republicans to just vote majority to get it through. Why would that be a nuclear option if Mitch McConnell did away with that 60-vote threshold?
One of the great traditions in the United States Senate is the filibuster. Depending on which side of the aisle you are at a particular time politically, McGraw, majority or minority, affects your view of that. But it is a great tradition. Several years ago, there began to be filibusters for presidential nominations, specifically presidential judicial nominations. And the rules were changed that judicial nominations could not be filibustered except Supreme Court nominations. And so the nuclear option is that if the Republicans in the Senate decide to change that rule, to nuke it, so that it only takes a majority to confirm a Supreme Court nominee. So what is being nuked is the filibuster rule that currently applies to Supreme Court nominees.
If that happens, I mean, they're not talking to each other now. They don't even agree that it's Wednesday in Washington,
You know,
D.C.
if that happens, you wonder whether they could sit in the same room at the same time.
Right.
But I think McConnell is perfectly capable of saying, you know what, Senator Schumer, we think what's sauce for the goose is sauce for the gander, and we are going to exercise the nuclear option.
Right. Which hypocrisy is all over the place when it comes to this, because they sat on the Merrick Garland deal. And then if you go back and you look at what the Republicans were saying when it looked like Hillary was going to win about the Supreme Court, you know, they would have gone nuclear if they would have done away with the 50 with the 60-vote rule, right? But now that the Democrats own or the Republicans own everything, now it's can't you just get along? This is a traditional pick, right? I mean, the hypocrisy is flowing tremendously in Washington D.C.
as if that ever stopped them. There's a great
Yeah,
there's a great line
shocking.
there's a great line in the play Marmee and McGraw that applies. Oh, what a tangled web we weave when first we practice to deceive.
Right.
And I think that is flowing on both sides of the aisle.
Greg Willard, I have a theory to help out the other Democrats on this. And let me run this by you as a former White House staff assistant lawyer. And that is this. I think the Democrats should start praising Neil Gorsuch and say, oh my goodness, we lucked out. What a great pick. Oh my goodness, we love this guy. This guy's tremendous. I think Claire McCaskill should hold a news conference and say, I'm going to vote not just vote for him, I'm going to vote enthusiastically for him. I love this guy. And the more the Democrats like him, the more the conservatives would freak out. Right? Wait a minute. Why do you guys, if you guys like him, we have to hate him? And so he might be derailed by his own party.
Right. And, reverse psychology.
Yes.
I love the appeal of that. I think the reality is, McGraw, that qualifications, I mean, let's be blunt, qualifications have nothing to do with what this fight is going to be about.
Right.
What I think is equally interesting is, if you remember last fall, McGraw, and we talked about this on the air, Trump did something that was unprecedented in American presidential election history. He put out a list of who he was going to consider, if elected, as Supreme Court nominees. There's a poll out that 56% of the people who supported Trump at the ballot box in November, the Supreme Court pick was their number one consideration. As I have said on this show many times before, McGraw, what we saw last night is a perfect example of the adage, this is why we have elections.
Right. This is elections have consequences. I want to get to the Attorney General's situation, but one more question about Neil Gorsuch. Why is it that when they nominate so-called conservative justices, it seems like sometimes they don't rule conservatively, but when when the liberals pick the liberal justices, they stay liberal on the court?
I think you could probably get some statistical support for that. I think there are those of the conservative persuasion that say David Souter was a disappointment for President George H.W. Bush. And then they would say, well, look how Justice Breyer, Justice Ginsburg, Justice Kagan, Sotomayor have been true to the ideals with which they thought those four would carry out their duties. So I think it's tough to predict how one will rule on the Supreme Court, but I have heard those before say the Republicans have not been quite as successful in their picks over the years. That's why I think they should come out and praise this Neil Gorsuch and drive him crazy. Greg Willard is with us, St. Louis University law professor. Hold that thought. We got a lot more to get to with all of the firing of the acting Attorney General and the current Attorney General, who is a St. Louis University graduate. We'll get to all of that here in a second. Greg Willard, St. Louis University law professor, KTRS legal analyst, appliance discounters, ladies and gentlemen. Greg Willard with us, St. Louis University law professor. This is interesting. Let's start at the beginning, Greg Willard. Does the Attorney General have to do everything the president says? Are they the president's lawyer? How independent is the Attorney General? I'll give you two answers, a practical one and a technical one. The practical answer is they are independent and they can exercise independent judgment. So they can stand up to the president if they so choose? No. Okay. Because under the Constitution, we have one executive, and all of that power, including the Justice Department power, is in one person, the president. So the Attorney General can stand up to the person in terms of disagreeing, advocating a different position. But if the Attorney General is given a directive to do something, the Attorney General has one of two choices. She can either comply or quit. And if she does not comport with that, she will be fired. Go back in history, McGraw. There are several examples. The Saturday Night Massacre with Nixon. Nixon gave an order, Elliot Richardson disagreed with it. He quit. The Deputy Attorney General Ruckelshaus quit. Secretary Cyrus Vance disagreed with President Carter's Iran rescue mission. He quit. General MacArthur disagreed with President Truman. Same situation. And countermanded the directive from the president. He was fired. Acting Attorney General Yates countermanded the directive of the president. She was fired. And I think the mistake, or where I disagree with former Acting Attorney General Yates, is if she disagreed and was uncomfortable having her department defend the immigration executive order, then she was duty-bound to resign. She did not. What I found very, very troubling was this letter that she sent to the department saying, quote, "The Department of Justice will not present arguments in defense of the executive order," close quote. That is extraordinary, and whether it's a Democratic president or a Republican president, she deserved to be fired.
John Ashcroft, Attorney General, deathly ill in bed. They come to him and say, sign off on this interrogation technique. He says, I won't do it. They go back to him. They say, no, you need to sign this. He says no. James Comey then stands up and says, no, he's not doing it. Bush changes the executive order to appease John Ashcroft.
Correct.
Goes back, and then John Ashcroft signs it.
And FBI Director Mueller was involved in that same process. And the historical footnote is, the next morning before it was changed, both Comey as Deputy Attorney General and Mueller as FBI Director, they told President George W. Bush, if this goes forward unchanged, we will resign. That is what a member of the executive branch, whether it's the Attorney General of the United States or some GS5,
right,
that is the choice that they have, to either comply with the directive of the president or their superiors, or resign if you so fundamentally disagree. And again, the fact that former Acting Attorney General Yates disagreed with the executive order,
right,
that's fine, and she can advocate that position. But if she is so uncomfortable that she doesn't want the department to enforce it, she is constitutionally not empowered to direct her department not to enforce it. She has to quit.
And so you're saying Bush said, okay.
They changed it.
I understand that. He could have said, I want to do this anyway. They would have resigned.
And Ashcroft, Deputy Attorney General, now FBI Director Comey, would have resigned. Then FBI Director Mueller would resign. Instead, the president changed it. Now
the Acting Attorney General is Dana Boente, a SLU graduate. Do you know Dana Boente?
You know, it's interesting you bring that up. One of my former law colleagues and I were reflecting last night. We think our paths crossed with young Mr. Boente early in the 1980s when he was a SLU grad. He's from Carlinville, Illinois, just up the road, small town, downstate Illinois boy made good. But from everything that I have read after he left SLU Law School, he has had a terrific and very extraordinary career of public service.
Greg Willard, St. Louis University law professor. Hopefully you're paying attention. This class is worth 3 credits towards your law degree. So I thought that if a president signs an executive order, by definition, it's legal. So people keep saying, hey, this is illegal. He can't do this. He can't have a carve out for a religious exemption for Christian minorities from these 7 countries. If the president signs an executive order, isn't it legal by definition?
Change your nomenclature a little, McGraw. I think the question is it constitutional?
Okay.
And so the question is, if he signs, let's just posit an extreme. He signs an order that says, if you are a Muslim, you can't come to the United States. That is likely going to be subject to a significant constitutional challenge. That is not what he did. A lot of people would like to think that is what he did, but that is not what he did. But just because, as a technical constitutional matter, just because a president signs an executive order, it is not ipso facto automatically legal and unchallengeable. Having said that, and I haven't studied it thoroughly, but if I were a betting man, I would bet that the constitutionality and the legality of his executive order will stand.
Through these challenges, you mean?
Through these challenges. You've got the city attorney from San Francisco and the ACLU and lots of folks that feel they are very aggrieved. But I think at the end of the day, it will stand both on constitutional grounds, but as a proper and authorized discretion of the president under the statute, the immigration statutes.
One of the things I am not able to, I don't know, and I'm going to ask you, and it's okay if you don't know this, but I have yet to find this answer. These lawsuits that they have ruled against the president in these 5 that have come down. Are we living under his executive order now, or has it been stayed until the courts are able to hear both sides?
Well, let's be very careful. His executive order has not been struck down. What happened over the weekend was there were a group of individuals who were detained and were on their way to being deported.
Right.
And a federal judge entered what is called a temporary restraining order, a TRO, that said, wait, let's preserve the status quo. I don't want them deported until we can sort through these constitutional and statutory issues. That's much different, McGraw, than a federal judge adjudicating that the order is unconstitutional or illegal.
Okay.
And that has not happened. All that has happened is relief has been given temporarily to a very, very small group to prevent them from being deported.
So this group is being held somewhere else because the government said they're not holding anybody.
Oh, I don't think they're being held. I think the order simply prevents the government from deporting them. So
they were allowed
I don't think,
to. Okay.
Yeah, I don't think they're under arrest because they haven't committed any crimes.
So over the next couple of days, we're assuming these courts are going to hear?
Or in the next 14 days.
Next 14 days.
48 days, there will be a subsequent hearing as to whether the TRO ought to be extended or whether it should be dissolved.
Any question I didn't ask that you want to lend your expertise to? Because there's quite a bit the last 72 hours.
Well, I guess let me just touch briefly on this emoluments clause issue that has kind of gotten swept up in the cacophony. There's been a great hue and cry that President Trump, less than 2 weeks into his presidency, is violating the Constitution through the emoluments clause. What the emoluments clause says is that no person holding a federal public office can accept a present or an emolument from a foreign government. And the question is, because he has ownership of corporations that do business overseas and then have customers in the country, is he receiving an emolument? Well, if George Washington's nephew or George Washington's 5th cousin received a pewter set from the King of England, did George Washington, quote, receive a present? I don't think so, McGraw. So where do you draw the line in terms of levels of consanguinity between the president and then his holdings or his family? So it's great political fodder for the Democrats, this emoluments clause, but I think at the end of the day it goes nowhere.
The other side would say, we don't know because he hasn't released his taxes. And the other side would say, you know what? Granted, his sons are running his empire now, but he knows everything that's going on, so he's going to directly benefit because his sons are running the world.
Well, my dear friend, why don't I join your skeptic role right here and go one step further? Could it possibly be that the plaintiffs in this lawsuit are not really interested in the emoluments clause, but rather the possibility that in discovery and federal litigation, which is what this is, they will be able to get a copy of his tax returns. Could that possibly be a motivation for this lawsuit instead of trying to uphold the sanctity of the Constitution?
Ladies and gentlemen, your next step is to the bursar's office. You owe us 3 credit hours. We will send the bill directly to your parents. Greg Willard, St. Louis University law professor, White House staff assistant in the Ford administration. He became his personal attorney and now a attorney for the Gerald Ford Trust. Get back to work. Thank you very much. Great stuff today.
Oh, great to be with you, my friend.
9:34.